Welcome to the Pregnancy Help Podcast. I'm Christine Grimmett, and I'm here with Heartbeat International President Jor-El Godsey and our General Counsel, Danielle White. And a lot has happened and is happening in the pregnancy help movement and abortion pill reversal on the legal front. So today we're bringing you updates on where things have gone in the past year or so, and maybe some insight into what could possibly be next as we actually start nearing the close of this year. And another way to continually stay updated is through pregnancyhelpnews.com, where you can sign up for weekly news updates, and also by listening to our monthly Pregnancy Help News Brief episodes here on the Pregnancy Help Podcast. Those are published the last Wednesday of each month, bringing you the highlights from Pregnancy Help News. Well, Jor-El and Danielle, it's so good to have both of you here. Let's get started.
Thanks, Christine. Well, actually, we just passed an anniversary. It was 12 months ago in September that we had our staff meeting, which is every third Thursday of the month. And after the staff meeting ended in September of 2023, was when we had been reached by a reporter saying, "Hey, you're about to be sued in 15 minutes by the Attorney General of the state of California, Bonta. Do you have any comments?" I was like, well, this was complete news to us. And so here we are, a little more than a year later, having passed that anniversary, and a whole lot of things have been going on. Sometimes they were racing like crazy to things were happening, and then we go for stretches with very little happening. But we're going to talk about all of that. Let's start in California, Danielle. You remember that moment when we were notified that we were, or at least when we learned, we weren't so much notified as kind of leaked that this was going to happen. And then, of course, AG Bonta had a press conference, and then we get served and we're off and running. Catch us up.
Yeah, that's right. So we learned that we were being sued for deceptive practices and unfair business activity with in connection with our APR activity. So the AG takes issue with Heartbeat speaking about the possibility that women might be able to reverse their in-progress chemical abortions. They say that that's deceptive speech and an unfair business practice. So we are in state court in Alameda County defending the right to speak about APR. So we're defending that right with real options out there, and it's been a journey. And something that's been really curious about the case is it's been a slower pace of litigation than what we might expect. Normally, when a plaintiff brings a case, they are pretty concerned about whatever is going on. That's why they're willing to take legal action, and they're usually interested in pushing that legal action to happen quickly. Our experience has been that the pace has been much slower than we would expect. So that's curious and kind of interesting. But we had our first set of hearings back in May. So we were sued in September. It took till May to get a hearing. And those were on our challenges to jurisdiction and a motion to dismiss for basically like a legal insufficiency in the complaint. We weren't too surprised when we lost on both of those motions. So we are proceeding now to discovery, which is a long process, but we are so steadfast in our resolve to defend APR in the state courts. And it's been interesting to see some of the federal actions that are popping up as a result of this state case.
Well, one of the things that we had to make a quick decision on was representation. Like who's going to join us in the legal fight? And the good news was we had great national partners who are able to pivot and work in many states, if not all of the states at some point. But we were able to connect with Thomas More Society early on. I remember that phone call. They were eager and anxious. They had a great partner that was based in San Diego, so very familiar with not just California law, but also with this particular attorney general, having been sparred with him in many different actions. So we were grateful to bring on Thomas More Society, whose primary legal counsel is Peter Breen, and a group out of the San Diego, the Lamandry Jonah group. And so we have had a lot of friends helping us with that. And because even the language is different in each state. Is that right, Danielle?
Yeah, that's right. The procedural aspects are different, and how the case proceeds is different, and so even just knowing the lay of the land is super helpful. Yeah, Thomas More Society reached out as soon as they heard about the case, and they were very, very supportive and eager to help. It just so happened that I had been a summer associate with them back in the day before I graduated from law school, so I was familiar with them and excited for the opportunity to work with them again on this case. As you mentioned, Jor-El, Lamandry and Jonah has litigated against the AG, the California AG, I believe it's 9 times, and they've won every single time. So with a record like that, we were yeah, we were pretty excited to have them as our representation, and they're doing a great job.
Yeah, and so you've been out to travel to be there for a hearing that occurred, I think, back in May. Again, this is kind of slower pace than we expected. Initially, there was a flurry of activity, and then suddenly it's kind of slowed down, and so things aren't moving fast, but they are moving, right? So there's discovery happening. But meanwhile, this is a state action, and this is one of the dynamics we're becoming more familiar with, at least as a non-lawyer I am, is that the idea that you have actions that are happening in the state, but then you also have there are reasons, and then there are also strategies as to why to have such actions also happen at the federal level. First of all, can you kind of explain the dynamics of a state case versus a federal case? And then we're going to jump from that, obviously, into what's happening federally in California.
Sure. So, as I mentioned before, there are different procedures in every state, and that's the case with state court too. So, the state court is going to have different procedures. Sometimes they may have a higher volume of cases, and so they may not be able to proceed as quickly as the federal courts can proceed. And then the federal courts also are much more accustomed to dealing with constitutional rights. So here, clearly, the right to speak this message, this life-saving message about the possibility of reversing an in-progress chemical abortion, there are First Amendment implications there, very serious First Amendment implications. And so there are others who would like to speak this message as well, who are being silenced because of their fear of having a retaliatory action brought against them just because they have exercised their First Amendment rights. So
Okay, hold on. So when you talk about the First Amendment right, you're really talking about the Constitution of the United States. And then the state action, though, is really about the Constitution of that state, because all the states have their individual constitutions, for instance. I mean, that's kind of how we were how we were created, going back to the 13 original colonies, had all their different constitutions and whatnot. So the local judges, the state judges, are really looking towards the state constitution. With in the background is the federal constitution, right? The one that we always know. So when you say First Amendment, that's actually in the federal constitution, which is then, so that's, to me, that's the dynamic. So the state of California has written some very interesting language into their own, including protecting abortion and other things, into their own state constitution that doesn't occur in the federal constitution. And so that's some of the dynamics that the judges themselves are dealing with.
Right. And we did make federal defenses. You know, obviously we've appealed to the fact that we have federal protections over this speech, but the state court judges are, as you said, much more accustomed to analyzing their own state constitution and their own state laws. And so when you get into federal court, you have that more federal perspective, a little bit more experience analyzing and dealing with those issues. So that's important. I want to back up, Jor-El, because you mentioned the California Constitution and the particular rights that are encompassed in the California Constitution. You know, one of our arguments in the California state case is that Heartbeat has broad protections for speaking these messages precisely because California protects certain reproductive rights on such a high level. And so the California Constitution protects the right to continue one's pregnancy, and there's language granting immunity to anyone who is helping a woman to vindicate those rights or to exercise those rights. And so we have argued that Heartbeat is assisting a woman in exercising her fundamental right under the California state constitution to continue her pregnancy. And so that's an argument that we're definitely going to make in state court. Now that will be a state court specific argument. That argument won't be quite as available in federal court. So there's just different arguments that can be made in the different venues depending on which law we're looking at.
Which goes to show that you need to really have someone who knows that local state law really, really well as the federal. Like everything can't just automatically flow to the federal necessarily, as we're finding out with these attorneys general actions, not just in California, of course, but elsewhere. So you started to mention First Amendment and the federal cases. To my knowledge, there have been two federal cases that have been brought with a similar dynamics, keying into, as you said, the First Amendment protections and the fact that some speech is being chilled, which is it's like I hear this word chill, and normally, like when we say Netflix and chill, it doesn't quite mean the same thing when we're talking about chilling of First Amendment rights. That's actually a very important concept that is necessary for us to understand as we talk about these federal actions. So, as kind of tease it out, Danielle, one of the things that you're exceptionally good at is making complex legal concepts very simple for us non-attorneys to understand.
Yeah, so in federal court, the argument is basically along the lines that the AG's actions against pregnancy centers have been so aggressive that pregnancy centers now feel fearful or are self-censoring their own speech. They would like to speak this message. They would like to exercise their First Amendment rights. They would like to tell women about the possibility of continuing their pregnancies. But because the Attorney General has been so aggressive, they are fearful in doing so. So that's the chilling aspect.
That's a chilling aspect of when a government it's really moving in and making some type of argument. And you say aggressive, but even the fact that they're threatening action. I mean, that's what they're doing against Heartbeat and against our friend Real Options, is they're threatening fines and other actions, which then, of course, if someone's watching the government do that, they're not just going to run out and say, oh, well, I'm going to start doing that now too. I mean, and that's the idea when you say that their speech is being chilled, it means their actions are being adjusted based upon what the government threat is or has threatened to do. And that's why it's important for these actions to be also brought at a federal level. Now, Heartbeat's not in those other actions, but mostly because we're in the state one. But we do have some friends who are in those two, and I believe there's two of them.
Yeah, that's right. And I'll just say too, this isn't something that's happening in a vacuum, this chilling of abortion pill reversal speech. This is after a long history of California attorneys general trying to silence and suppress pregnancy centers. And so it's not as if, the pregnancy centers have seen one instance of a attorney general taking aggression against pregnancy centers. This is a long history. We had the NIFLA case, back in 2018, when was decided back in 2018. But then we've had, the consumer protection advisories and various other ridiculous targeting of pregnancy centers. And so it's all of it. It's this environment that the AG has created that is intimidating pregnancy centers. And so it's for that reason that NIFLA, along with Santa Clarita Valley Center, they've sued in federal court in one district out in California, and then in a different district, Culture of Life Family Services has also sued. And they're just looking for the court to say, you have a right to speak this message. That is such a fundamental bedrock right here in our country, that we have the right to speak a message. The government may not like it, the government may not agree with it, but the government may not suppress it simply because they don't like it and they don't agree with it.
Well, certainly the abortion favoring politicians, including this attorney general, doesn't like the speech of abortion pill reversal. For whatever reason, it's hard to understand actually for us, because we see it as a choice that she should have, and it's sad to see such abortion-minded individuals deny her the choice to change her mind about her abortion pill that she just took, and who then really are saying that she shouldn't know about the opportunity to change her mind, and should be ultimately would then, in my mind, be forced to continue with an abortion she no longer wants. Like that's the saddest part of all of this, is really the effect of it on the ground for the sake of the woman, for those who really want a different choice than what the one that they've made. But this is the actions of attorneys General Bonta and then also Letitia James. So we have action, we have state action, and then federal action in California, which right now, like you said, at least the two federal ones have just been announced in the last 6 or 8 weeks. And so they're in that early phase. We are a little bit further along. We've had the hearing. So now we're in a discovery phase, which takes forever. So that's a discovery phase where all those things get pulled together and get passed along for the other attorneys. All right. So we're not just in California. As we've reported on before, we were in the midst of our conference in Salt Lake City in April when we learned that Attorney General Letitia James was also wanted to get in on this adventure, and we learned that not one center, like in California, where our friends Real Options are, and Heartbeat, but actually 11 centers and Heartbeat International have been contacted about were contacted about an intent to sue. And we've talked about that story. It's an amazing story that happened actually while we were together. There was a lunchroom table that happened to have all of the happened as the Lord would allow, providentially. They were all at the table while it was being discovered that these things were landing in different places. And the question was, what could we do about it? Great minds were at that table. And frankly, before the end of the day, there was action planned. There was agreements happening. And within 5 days, not waiting for Attorney General James to sue us, we were able to sue Attorney General James on this same matter. And again, our friends at TMS kind of led that effort. Peter and team, having just been really, immersed in this in California, we're actually quite well positioned to have the same conversation, a very similar conversation in New York. And so that's taken a little different turn. That because we were able to sue, that created some dynamics, Danielle, that kind of had a back and forth. There was a flurry of activity over a very short amount of time. And so give us a little picture of that and then where that's gone since then.
Yeah, sure. So in New York, we were able to sue we sued the Attorney General in Monroe County, which is the Rochester area. The reason that we went to the Rochester area was because some of the defendants or plaintiffs, as it were, some of the pregnancy centers, were located in Monroe County. Manhattan is the most expensive place in all of the country to litigate, and none of the centers who had received notices were located in Manhattan. And so we sued in Monroe County to try to make litigation more affordable and accessible for the parties to the lawsuit. Attorney General James did not like that. And so just about a week later, she sued us in Manhattan. And then there was a lot of legal back and forth essentially as to where this case was going to actually proceed. Again, Manhattan would just be very, very difficult for the pregnancy centers because of the cost of litigation, because of how far away Manhattan was for some of the pregnancy centers. And the AG has an office not far from Rochester. And so, kind of the balance of the interests there, it seemed to make sense that the case would proceed in Monroe County. And so eventually, after a lot of back and forth and a lot of time and effort, the Monroe County judge did decide to go ahead and consolidate the cases into Monroe County, and that's where the case is set to proceed. However, the Attorney General did not like that ruling, so she went ahead and appealed that. So that's where we are in the state case in New York. We're awaiting that appeal. The appeals process is relatively slow. Again, these are the differences between state court and federal court. State court, things just take longer. And so the Attorney General's brief to open that appeal isn't even due until sometime around Christmas. And so there will be nothing happening on the Heartbeat case with those 11 other centers until sometime around Christmas when the AG begins the appeal, essentially, with a full brief setting forth her arguments. Then we'll have a period of time to respond to those in writing. There may or may not be an oral argument. Sometimes there is, and sometimes there isn't. But it's going to take a while before that case even gets into the actual merits of the case. So right now we're just arguing about where we're going to argue. And then eventually, once that question is settled, we'll actually get into defending our right to speak about APR.
Which we're most confident about that. Like if as long as we can have even a semblance of a fair review of the facts, whether it's California, New York, like New York, we are very confident in the research. We're very confident in our position. We look very much forward to being able to make that defense and defend strongly. Like we're not worried about that. We're excited about it. And yet all of these legal wranglings, are part and part of the effort to help defend that. Now, in New York, though, we've also had similar federal action, and unlike California, there's actually been not just action, but some good news have come down from that process. You want to kind of unpack the federal pieces that are happening in New York.
Yeah, certainly. So NIFLA and our friends at Alliance Defending Freedom initiated a federal case. So similar concept to what we just discussed in California. That case is taking place in the Western District of New York, and they moved for a preliminary injunction. So a preliminary injunction, if you win on a preliminary injunction, it means that the state can't enforce can't take any action against APR, essentially, during the case, as the case is pending. So a preliminary injunction almost is a little preview of the case. It looks at the arguments that both sides are going to make, and in order to win a preliminary injunction, the plaintiff, or in this case NIFLA, represented by ADF, must be able to show that they have a likelihood of succeeding in the overall case. So it is a little bit of a case before the case. And so that preliminary injunction hearing took place back in August. And then in less than a week's time, the judge there in the Western District of New York issued a preliminary injunction in favor of NIFLA and in favor of APR speech. It was a strong opinion. It had some good language about just how insidious it is when the government tries to determine what truth is, when the government tries to insert its own opinions and its own message into the people's speech. So it was a strong opinion. The AG did appeal that preliminary injunction to the Second Circuit, and that appeal is pending, but it will be quicker than our appeal in the state case. It's kind of interesting because it all kind of is converging around the Christmas time. Between Thanksgiving and Christmas is when a lot of these briefs are going to be due. So that one will have some activity also towards the end of the year, with the AG filing their appellate brief, and then ADF and NIFLA will have an opportunity to respond.
Well, and that's very, it's just curious because how all that works, because the concept of local government is supposed to be one that is more responsive and quicker to deal with local issues. But in this case, the federal effort is moving much more, or has moved much more quickly to at least get to a next step scenario, which is, of course, now we're in the place where all of that is in question as far as the appeals, because both have been appealed in New York. But Danielle, why can't, I mean, we have a good declaration from a federal judge. Why doesn't that just halt the state action?
That's a great question. So it doesn't halt the state action because it's not done yet. So the case isn't over yet in the federal case. The state courts could arrive at a different conclusion. In New York, it would be a little more unusual for the state court judges to arrive at a totally different conclusion, although they could. But then there's the reality that the New York decision and the Second Circuit decision is not at all binding on the California case. And so what that kind of invites is the possibility for an eventual circuit split. What that means is as these federal cases proceed, assuming that there's maybe an appeal out in California somewhere along the lines, that could go to the Ninth Circuit, and then there is a possibility that the Ninth Circuit could decide something different from the Second Circuit. When that happens, it's much more likely that the Supreme Court can get involved, because the Ninth Circuit and the Second Circuit are both interpreting the same document, which is the U.S. Constitution. And so it's not good to have a scenario where the U.S. Constitution means something in California and something totally opposite in New York. So that's a possible path forward for these cases.
That is if we get two different decisions at those at the district level in the federal cases.
Correct.
Because the Supreme Court kind of has to resolve those. Like the way I understand it, I know you taught me this, that the Supreme Court grants cert, which is short for some long Latin word, certiorari, with a bunch of letters and a couple of consonants. But so grant cert, but they don't do that for every case. So it's not like you can just automatically appeal things up to the Supreme Court. They actually have to accept that. I've learned that requires 4 of the 9 justices to accept that. Otherwise, they let the district court ruling stand. However, if they've got 2 different district courts ruling different things, then they're almost compelled to resolve that issue, because that is something that that's really their duty as Supreme Court, is that there's a consistency across the judiciary.
Yeah.
But all of that would happen like in parallel to the state. Is that correct?
That's right. Yeah. Yeah, the Supreme Court is much more likely to take cases that involve circuit splits. They don't have to. They take a very, very, very small number of cases of all of those who apply for a hearing before the Supreme Court. And so it's possible that even a circuit split wouldn't do it yet. Maybe we would need a few more circuits weighing in, but a circuit split is definitely something that would get their attention. The state court cases can proceed at the same time. They could come to totally different outcomes. But if the Supreme Court speaks on the matter, that's going to be that's a pretty heavy weight coming in there.
I mean, wouldn't that be that'd be the easiest citation to make, right? Well, guys, hey, what you guys are discussing here locally in your state has actually been ruled on by the Supreme Court, and here's the citation for that. That would be a pretty straightforward offering. So for now, what are you next waiting for, Danielle?
I'm really interested to see I'm kind of a little bit of a legal nerd, so maybe this won't be as interesting to others, but I'm very interested to see the appellate briefs in the Second Circuit, and also to see A.G. James' appellate brief in the state action. Because I'm just curious to see what kinds of arguments that she will make to try to move the case from Monroe County to Manhattan. So those are coming in the next couple of months. So that's what I'm looking for. We're still working on discovery. That is a long, arduous, and very laborious process. It's extremely time consuming. And so we're working diligently on that out in California. Our hearing date is set in California. Everybody mark your calendars. It's set for November of 2025, and those are subject to change, and I would be very surprised if it does not change. So it's a long battle. We're in this for a long while.
It's too important to not be prepared for the long haul. And I would make this observation. There are several centers, many centers that are in the New York case. There's one in the California case. And Heartbeat, of course, is in both of them. And our friends at NIFLA and other centers are in the federal ones. If these succeed, and by succeed, I mean if the opposition gains the foothold that they want against APR, then this matter comes not just to these handful of centers, but really becomes to everybody. So it's critical for us to fight these battles. I know it wasn't in the job description when we hired Danielle. Oh, let's tangle with state attorneys general, but she's done a great job, and she still keeps smiling, which is very helpful, even if it does cost her sleep every now and then. Which, as a mother of 5, and that has its toll already. But let's switch gears a little bit, and let's talk about a kind of a different attack on APR, which is that in the state of Colorado. So with the few minutes we have left, let's talk about Colorado. They actually had a legislative maneuver where they basically powered through an APR ban. At least that was their effort to try to kind of make it very unpalatable for providers and prescribers to really be able to provide APR, abortion pill reversal, which is, by the way, again, just progesterone. And so they did that, but then our friends in the heart of Denver, Bella, was able to challenge that. Give us an update on well, first cover where that was, where it's gone, and then where is it now?
Yeah, so back in 2023, the Colorado legislature saw fit to suggest to the boards of pharmacy, nursing, and medicine that offering APR should be professional misconduct. So what that means is that any medical provider whose license falls under those three boards could be subject to professional discipline or possibly losing their license if they offered abortion pill reversal to a woman seeking that service. So, Bella Health, a Colorado center represented by Beckett, they sued back in 2023, April of 2023, seeking to vindicate their First Amendment rights to offer this service. You know, it's really interesting. These The opposition to APR really reveals that these people are so pro-abortion that they cease to be pro-choice anymore. They're seeking to take away choices from women, and it's so absurd when you line up. You may have a woman on the one hand who is naturally progesterone deficient. 12% of all pregnancies require progesterone supplementation because of a natural lack of progesterone in the woman. If you put a woman who is naturally progesterone um, needs progesterone supplementation because she's naturally progesterone deficient, she can receive progesterone from her OB. That's not a problem. The Colorado law does not outlaw that. But then you take a woman who has initially chosen abortion and is progesterone deficient because she took a drug that makes her progesterone deficient. And the Colorado law says she cannot have access to progesterone. And so, what this law really does is it takes rights away from women who are seeking abortions or who have started abortions. In other words, it makes women who have started abortions second class to the women who are just naturally progesterone deficient. And that's not really like a critical part of the argument in Colorado, but it's just so fascinating to think about the way that these AGs are really harming abortion seekers, which are the people that they claim to protect. So Bella has a First Amendment claim under the Free Exercise of Religion clause. So Congress shall make no law inhibiting the free exercise of religion. So what Bella is arguing is they offer abortion pill reversal out of a religious conviction that they have an obligation to save the life of somebody whose life is in danger. In this case, that is the unborn child whose life is in imminent danger if they don't receive progesterone supplementation after mifepristone. Of course, all when a mother is desperately seeking to save the life of her child. And so Bella Health has argued that their religious obligations to assist a woman in this situation, that's what brings in that First Amendment claim that they have a free exercise right to offer these services that their religious convictions require.
And they basically filed a federal lawsuit, like immediately following that passing the legislature, being signed by the governor. Right, that they enacted that quickly, and they did so in a federal way, not in a state way. And then that was actually reviewed by a appellate judge in the Colorado, not an appellate, tell me. A federal district judge?
Federal district judge.
Okay.
So Bella filed suit back in April, and then they also filed for a preliminary injunction. So that's that case before the case. They asked the court to pause the enforcement of this law while the courts are in the process of actually reviewing whether the law is constitutional. So there was a hearing on the preliminary injunction, and then that preliminary injunction was granted. And so the judge who looked at that issue determined that Bella Health has a First Amendment free exercise right to offer abortion pill reversal to women. Now that's on a preliminary basis, and that could change as the case progresses, or when the case reaches its ultimate conclusion. But the Bella Health won the case before the case, if you will.
So Bella's able to serve APR clients. By the way, also currently APR is still happening in California and New York. It's not true. People have been hearing like, oh, I heard APR was banned in California, banned in New York. No. Yes, there have been actions in Colorado to attempt to do it, but all of that's been called into question by the litigation. So, all right. So as we finish out here, what's the one thing you want us all to do, Danielle?
I would just ask everybody to pray. Pray for favor in the courts. Pray for these litigators who are working around the clock to defend APR coast to coast. Pray for Beckett. Pray for ADF. Pray for Thomas More Society.
Okay, so Beckett in Colorado, and then specifically, and because they were the ones that filed that case, and then of course
also
both
ADF in Colorado.
Oh, that's right. ADF, that's right. They added another case with the nurse midwife, as I recall, right, who was prescribing progesterone. Yeah, so they're in Colorado. Both ADF and Thomas More Society are active with cases in California and also New York. And there are other cases that we can talk about. We'll talk about at a different legal update. But for now, we wanted to make sure we covered the APR specific ones as well. And we look forward to maybe having some of our other legal friends join us to unpack some of their perspectives on these and other similar things. This is a wild and woolly environment related to pregnancy help. As someone once said to me, it was a quote that comes from World War II. If you're not feeling the flack, you are not over the target. Well, clearly we are over the target, have been over the target, because we are certainly feeling the flack. And so I would add to Danielle's list of prayer needs, if you'd also pray for Danielle, for wisdom, for the Heartbeat team, for the Heartbeat board. It takes time and energy and effort, and we're grateful to fight the battle on behalf of this so important movement. I believe God has raised up abortion pill reversal for such a time as this. And not to mention there are other things that are going on. We think maybe a win could help us with the censorship issue as well going forward. And so there are a lot riding on these cases, slow as they are to happen. Justice may be blind, but in some cases she also moves very slowly. But we're confident that we have the right facts, the right arguments, and we have a great legal representation all around helping us defend this. So thank you very much, Danielle, and look forward to our next legal update and hearing from more of our legal partners.
Thank you so much for having me.
Thanks, Jor-El and Danielle. It's really helpful to have that update. I know I've been following this for a while, but to get the timeline of start to where we're at now and where we may be at hopefully soon with more updates, it's really helpful to get that clarification. And we'll be bringing more to listeners as we find out more as those updates continue to happen. Again, listen to the Pregnancy Help News brief that happens monthly and follow Pregnancy Help News for further updates as well. It's great to keep everyone in the loop. And again, thanks for the prayers of all of our listeners as this battle is fought. So with that, I wish everyone a great rest of your day. And thank you for listening to this episode of the Pregnancy Help Podcast.